Hello and welcome, Vijay Srinivas. Well, the opposition is clearly upping the ante against election commissions, special intensive revisions in Bihar ahead of elections in November this year. You also see petition that's being filed in the Supreme Court. We just came for hearing a couple of hours back where the Supreme Court too had wrapped the poll body. But again, there's no sort of a stay on these revisions. We're joined by PDT Achary, former Secretary General of the Lok Sabha. So thank you very much for your time. Let me begin with you. Let me begin with you what the Election Commission had to say. The Election Commission of India had termed it a much-needed purification exercise of sorts, while the opposition expresses concerns about potential disenfranchisement, ahead of elections in Bihar. What's your stance on this, sir?
Actually, I have taken a particular stand. I wrote an article in the Hindu, which was published yesterday. So I have looked at the legality of the whole exercise, the special intensive revision, because the Election Commission has to go by the law. If there is a law, they have to go by the law. Certainly, Article 324 gives them a lot of powers to deal with all matters that arise in connection with the preparation of the electoral roll or the conduct of elections. So they have enormous powers under Article 324. But the Supreme Court has made it very clear that where the law is there, they have to go by that. Where the law doesn't exist in a particular area, where the Election Commission can take its own decisions, but then it cannot go above the law and the Constitution. That is, for example, the the basic requirement of rule of law and all that needs to be adhered to by the Election Commission. But otherwise, they have a lot of powers to deal with any kind of situation that may emerge in the course of the conduct of elections or preparation of roll or revision of roll and all that. But here there is a law. There are provisions, very clear provisions dealing with the preparation and the revision of electoral roll. I am referring to the Representation of People Act 1950. And Section 21 deals with all these various matters, preparation and revision of electoral roll. Electoral roll is prepared in four situations. One is before the election, whether it is parliamentary election or the assembly elections, the Election Commission can revise the election, shall, that means it's a mandatory provision. Election Commission shall revise the electoral list before the elections. Then in that case, the law has fixed a qualifying date. That means the revision should take place in that month, starting from that particular date. That is the meaning of qualifying date. And the law says that in these cases, the qualifying date will be 1st January. 1st January. So any revision that is to take place before the elections, the roll will have to be revised in January. That is the qualifying date. Now, if there is no revision, then what happens? The existing roll will be valid. That is also made very clear by the law. So far as the conduct of elections is concerned, there is no obstruction anywhere. On the basis of the existing roll, the election can be held. That is the thing. Now, before the election, before the by-election, rolls can be revised. But then there is another provision under which the Election Commission can give a direction to its officers to revise the electoral roll. Then also the qualifying date is 1st January. And there is a fourth case where Election Commission can do a very special revision in any constituency or a part of it. So that is a different kind of exercise. Revision, that is not a revision which will be done in the whole state. This revision will be done in any constituency. That means maybe a one constituency, maybe two constituencies, or maybe three constituencies, or a part of it. So when you say a part of it, it would necessarily mean one constituency where the revision will take place as per special direction by the Election Commission, and the Election Commission will have to show specific reasons for that, why they are doing it. Now the reason is, I mean, according to me, in my view, there may be some constituencies where under some circumstances, there may be an influx of people from another country, or maybe from another state or something. And there will be a kind of abnormal increase in the number of people who are in that constituency. And then in that situation, naturally, the Election Commission will think that there is a need for revising the role in that constituency. I think to cover such a situation, this provision has been made in the Act. Otherwise, for all other revisions, there is a qualifying date. That is now January 1. But in this particular case, what is not actually clear is the nomenclature that has been given to this revision. SIR, Special
Intensive Revision.
Intensive Revision. You won't find such a thing in the law. There is a provision for special revision, but special intensive revision, they have used it as a technical term, as some kind of an abbreviation of a term which is used in the law, which is not there in the law. The law says special revision. It does not say special intensive revision. They have used the acronym, SIR. That means they think that there is a particular term that is used in the law whose acronym they are using, SIR. That is not the case at all. And therefore, for the three revisions, January 1st is the qualifying date, but in this particular case, the special revision or the special intensive revision, they have fixed a qualifying date as 1st July. 1st July 2025. But if it is the revision, special revision that is referred to in the law, there is no mention about a qualifying date. There is no mention of a qualifying date for a special revision that is provided for in this section 21(3). But here it is a special intensive revision, and they have given a qualifying date also.
So I understand where you're coming, but I was listening to Mr. Ashok Lavasa, the former election commissioner, when he was talking to a national yesterday. He said it's a much needed exercise, but the contentious matter here is not just the constitutional validity of it, but it's also the timing of the procedure. Why do you think the Election Commission of India has chosen to do this at this point of time, the July 1st, as you said? Because elections are coming up. You see, if you were to connect dots, well, do you think there could be political ambitions on this case?
Well, I do not normally deal with the political. I don't normally deal with the political aspects of things. That is left to the politicians. But I will deal with the constitutional and the legal aspects of the issue.
Now, the question is the urgency justified? That's the question, isn't it?
No, that's what I'm going to answer that question.
Okay, please go ahead, sir.
No, my answer is that there was no urgency. Because after all, in 2024, they conducted the election on the basis of an electoral roll. So in 2024, if that electoral roll was valid, what changes have come about during this period in 1 year? That is something, which we don't really understand. So we don't understand the urgency. But as I was mentioning earlier, that if you want to revise the roll, you should have done it in January, not in July. And that you cannot arbitrarily fix a qualifying date. That is my point. You cannot arbitrarily fix a qualifying date for revision of the roll, because the law already has fixed that roll provider for that date, January 1st. That is the date which is given, provided in the law. So the Election Commission cannot go against the law and arbitrarily fix a qualifying date.
Okay.
Now the result of this exercise is that there is not much time left before the poll, and this massive exercise will have to be done.
Okay.
That is okay. So that means there is a departure from the law in fixing the qualifying date. Nobody is opposing revision of the electoral roll, because that is something which is done in accordance with the law. That's the thing. But here in this particular case, the first point is that there is, it is being done very late. Well, the elections are just a few months away, a couple of months away. And how can you do it in such a haste and hurry? And all these exercises will not be able to be completed before the elections. And that's a fear, people have.
That's right.
And then naturally people will think about the intention and all that. I do not want to go into the intention and all that kind of thing. I deal with the legal aspect, but legally, what I'm saying is, Election Commission has to go by the law, and the law provides that revision has to take place in January.
Not in July.
In January, not in July.
That's
so
right. Makes sense.
This has been fixed very arbitrarily, apparently, by the Election Commission.
Understand. Okay. Get your point, sir. But there are also reports that that Aadhaar is accepted in certain urban areas like Patna, rejected in rural areas like Seemanchal. Shouldn't there be a uniform standard of documentation approach when you do these kind of measures?
Certainly. Aadhaar, when it was introduced, it was to replace all other documents so far as your identity is concerned. Aadhaar gives you the address, residential address, and all that. So it was a complete kind of identity card, document. And for everything, for every transaction, Aadhaar is necessary. If you have to operate a bank account, Aadhaar is necessary. They link that to the Aadhaar. Aadhaar gives you everything about you to the authorities. But if that is not accepted as one of the documents, I am really surprised, as many others are. I do not know the reason why Aadhaar is not being accepted as a valid document for establishing your identity.
We also heard that birth certificates are being asked, and at certain places, there is a sense of worry, within the communities in Bihar that, if lakhs are removed due to, missing documentation or, lack of parental ID and so on, there is a bit of a juxtaposition with what has happened in Assam there with the NRC. Is that within ECC's mandate?
No, certainly it is not the mandate of EC to prepare the NRC. The citizenship law is dealt with by the Home Ministry. And it is not the mandate of the Election Commission to establish your citizenship and to determine your citizenship. It is not their job. That issue is dealt with by the Home Ministry, whether you are a citizen or not.
That's right.
That has to be decided and determined by the Home Ministry, not by the Election Commission. Election Commission's mandate under Article 426 is to prepare a rule. There, of course, it is mentioned that you have to be a citizen of India. That is the first condition for enrollment. You must be a citizen of India. And then you must be 18 years of age, 18 and more, not less than 18 years of age. These are the two conditions which are mentioned in Article 426. But the Election Commission's point is, since the first condition is that he should be a citizen of India, then who will decide that? So for enrollment, you must be a citizen of India. So how does the Election Commission ensure that you are a citizen of India? That question needs to be addressed by the Supreme Court. In fact, Supreme Court in number of cases, earlier in, I think some High Court or something, in number of cases had said that it is not the job of the Election Commission to decide whether a person is a citizen or not. Citizenship issue cannot be decided by the Election Commission.
But by the Home Ministry.
It is the Home Ministry's job, It is their domain.
Okay.
Then
Okay, so if large-scale deletions happen-
I will say one more thing in continuation
Go
of
ahead,
this. In case the people are not able to give all these documents which are asked for, then what happened? They will be out of the voters list. That is the consequence. Now, if you look at the electorate's registration rules, which are framed under this law, Representation of People Act 1950, you will find a particular rule which says, when these enumerators visit your house, they will ask certain things and you have to give them evidence. But it says, to the best of your ability. These words are very significant. To the best of your ability. I give information to the best of my ability. It may not be the complete information. I may not be having it. I am not able to collect that kind of information which you may require. But I am giving you information to the best of my ability. Now, for example, if a question is asked of the date of birth of my father, I may not be able to give that. I may not be able to give that. In fact, most of the people are not able to do that. So what they can say is that he was born in a particular year and he was born at a particular place. These are the two only pieces of information which I can give to the best of my ability.
Okay.
Now, if that is done, if that information is given, then you have to be enrolled. They can't reject you. That is the meaning of to the best of your ability. So that needs to be seriously looked into.
Okay. One last question before you wrap up. So if large-scale deletions happen, say the ultimate existence of the Election Commission of India to keep the electoral process fair, correct? So if large-scale deletions happen in constituencies dominated by a certain community, a particular caste, don't you think that this will hamper the very idea of the existence of the Election Commission, which is electoral fairness?
Yes, certainly. Election Commission's role is to enroll the maximum number of people, all the eligible voters. That is their job, not to exclude people. Election Commission's mandate is to enroll all the eligible voters in a state or in the country, and not to exclude them. That is it. So if they adhere to this primary responsibility, then I don't think they will be able to exclude people from the electoral list on some ground or the other. Question of citizenship, etc., that will be decided by some other authority, by the Home Ministry, if that is so, if that question comes up. But here, Election Commission will have to, first of all, see that all the eligible voters are included in the voters list.
Okay. Cool, sir.
That's
Thank
it.
you very much. Pleasure talking to you, sir. Thank you.